Hi everyone, welcome to our webinar. It's the employment law update for legal counsel, in which we're going to be talking about recent changes shaping the workplace. By way of introduction, I'm James True. I'm the practice group leader here in LegalVision's employment team. We'll get into it. Before we do start, just a few quick housekeeping matters. You'll get a copy of the recording and the slides in your email. You can put questions throughout, and if we have some time at the end, try and answer as many as I can. There'll also be a feedback section. We'll send you a survey. We're really keen for your feedback. We want to make these as helpful and useful as possible. So please do fill out that survey at the end. All right. You're also going to be eligible for a free consultation with our enterprise team, basically just to talk about how we can assist your business, any gaps we can identify, projects you might want to kick off. So again, leave your contact details at the end of the survey. We can be in touch with you about that. Also, you'll see we have a poll, and we'll keep that poll there, keep that up throughout the webinar, and it'll close just before the Q&A session, and I can share the results of that poll with you then. All right, we'll kick on. What are we talking about today? So these are the key updates in employment law. So wage theft, sham contracting, the right to disconnect, casuals, and then less recent in terms of updates, but always increasingly important. We'll just touch on some of the updates in relation to sexual harassment, and then sum up the takeaways and get into some Q&A at the end where we have time. We'll get right into it then, and we're going to talk about wage theft. So this is something which is brand new as of 1 January 2025, and the main thing here is that wage theft is now a criminal offence. This is a pretty big development, but it's also not an unexpected one. We've seen continued scrutiny from regulators, so the Fair Work Ombudsman, in relation to things like wage management, compliance, underpayment issues. Whereas, 10 years ago, where there were instances of underpayment, these weren't things that, businesses were necessarily particularly concerned with, although they might remediate them. Penalties weren't a huge issue, and media attention was not necessarily a huge issue, but all of that's flipped on its head. And now this is something that businesses take really, really seriously, both from the penalty perspective and then, of course, importantly too, the media scrutiny that you'll get. Underpayments now make the news in a way that they didn't ever before. When we're talking about the criminal offence of wage theft, this is about intentional non-payment of wages or your paid leave entitlements. So we're not talking about accidental, inadvertent, or genuine mistakes. But be aware that, what we have now as a criminal offence, we've got some pretty significant penalties, which, possibly quite the deterrent these days. So, potentially 8.25 million there for a corporation, or 3 times the underpayment amount, so whichever is higher. So these are significant penalties in a way that I think historically, the penalties we've seen for underpayments have not actually been a real deterrent for a business to make sure they're fixing these issues. And of course, a real kicker there, potential for 10 years imprisonment. Now, I know a lot of everyone joining there is part of a corporate entity. And, in terms of the fear you might have around going to prison for an for an intentional or a non-payment of wages there might be slim. But the important thing to remember is, there are still civil penalties for underpayment contraventions. So even if you might look at this and say, well, yes, I'm comfortable, I'm not going to prison because no one's running some kind of cashback scam. We've seen this historically where employers might pay an employee the correct wage on the books, but then require that employee to hand back half of that wage in cash so that they've been underpaid, but the paper trail looks like they've been appropriately paid. You might say, well, we're not doing any of that and we think we're okay. And even if you are okay on that front, the civil penalties are significant for underpayment contraventions as well. So even if we don't meet that sort of intentional criminal level, you're still looking at $1 to $5 million in penalties for underpayment. So Businesses need to take it seriously. And I think we'll move on here to the next slide in terms of, well, okay, with that in mind, what do you do about it? You really need to be proactive in this space. The first thing you can do is audit. And you can just do a spot audit. You might have hundreds or thousands of employees, and the process of auditing every single person's pay compliance might just be too complicated or too big a process, but do something. So maybe a spot audit, take the lowest paid section of your workforce. And even if you're not going to audit their entire last 6 years of wages, do a spot audit and look at the last 6 months or the last year. If you're doing that, you're going to be able to at least identify some anomalies. And you've got a chance then to get on the front foot. If you do find issues, you can deal with them basically before the Fair Work Ombudsman does. And that's a really critical thing to do if you're trying to avoid penalties. And then also all the downside of the media attention. You also need to understand entitlements. So many underpayments that we see don't come from, businesses trying to do their employees out of their wages. They come from mistakes, or they come from not just understanding what is actually owed. So an employee's entitlements are going to come from, firstly, the national employment standards, and then a higher level on top of that will be modern awards. Might have an entitlement to things like overtime, penalty rates, allowances, loadings, those things. You'll know if your business has an enterprise agreement, because that's going to be specific to your organisation, but it's another source of entitlement. And then, of course, contracts of employment will also confer entitlements on employees. So you need to understand where everything comes from, and in a sense, you can map all of that out. Once you understand what the entitlements are, that's obviously the next step is then ensuring that you have actually met those entitlements. Even where you're paying someone above minimum entitlements, you still need to make sure that your contracts of employment are appropriately drafted. So there's another common one. We have employers say to us, "Oh, but we pay above award, so we should be fine." But that's where it's critical to have a set-off clause in the contract, or a total remuneration clause. So basically making sure that, okay, that above award payment does compensate someone for all of their entitlements. Another common thing is training. So it's a sometimes missed, sometimes just assumed that the people who are in charge of payroll actually understand all those minute and the detail of those entitlements. And so it's an oversight, common oversight. There actually needs to be training on that, on the specific entitlements, on the modern award, and how to apply it to certain rosters, that type of thing. The final thing there is reporting channels, concerns and grievances. Businesses who allow their employees to raise issues and query a paycheck are going to be the ones who find out whether there are compliance issues very early on. And the sooner you find an issue, the sooner you can resolve it. And that is going to be your best bet to avoid penalties. So again, even if we're not talking about this intentional underpayment, where you're deliberately, doing your employees out of their entitlements, remembering that those civil penalties are significant for the inadvertent or accidental underpayment, you're still going to be fined for that. So being on the front foot is really, really critical when it comes to wage theft. We'll move on. We'd like to get through. The next one is Sham Contracting. These changes came in August 2024. So we've had them for a little while now. But to understand where we are now, it's probably a bit helpful just to do a slight little history lesson on where we've been. The law has kicked back and forth very significantly when it comes to sham contracting. Realistically, since the 90s, we've kind of constantly debated how this should be applied, but we've got certainty is the important thing now. From 2022 to 2024, we got some High Court decisions, and they made it, in a sense, very employer-friendly or business-friendly from the perspective of sham contracting, where they basically said, if we're trying to figure out if someone is in substance an employee or a contractor, we're going to look to the contract and the rights and obligations of the parties within that contract to make the determination. So if your contract sets out a contractor arrangement, then you've got a contractor on your hands. And in a sense, that created sort of 2 years where employers could very comfortably just call people contractors and just make sure they get the contract right, and the risk was really reduced. But this was quite a shift from what had been the historical position, which was the historical cases referred to, this concept of if it looks like a duck and it quacks like a duck, it's a duck. So we're going to forget the contract and look at the entire relationship. And this is what, as of August 2024, we've now come back to. But in a way that it's now actually very, very much codified within the legislation. We've reduced a lot of the grey area in terms of what is the test to apply to determine whether or not someone is a contractor or an employee. And under the Fair Work Act now, the way to determine that is by reference to the real substance, practical reality, and the true nature of the relationship between the parties. Now, that's all well and good, but it's still got a little bit of element of grey in there. We still have to make that assessment of the relationship. And how do you do that? Well, you look at 2 key indicia, and that is integration and control. So the integration side of things, how much does this person look and feel like they're part of our business? Or can we say that they're running a business of their own? The more integrated into our business someone is, the more likely we're going to be able to call them an employee rather than a contractor. And of course, the lower the integration, the more likely they're a contractor. When we look at control, a high degree of control, more like employment, a low degree of control, more like we have a contractor on our hands. Importantly, for control, we're not just talking about, well, you tell them what work to do, because even with a genuine contractor, you're still going to tell them what work to do. We're interested here in controlling the manner in which this worker performs the work. So if we give someone a task and say, look, you're the expert, off you go and do it, well, then we've told them what to do, but we've exerted a really small amount of control on what needs to be done. But if we're there saying, hey, day to day, let's do this bit of work, change this, and do it in accordance with maybe all of these set procedures, or do it in our way, then now we've got higher levels of control. So ultimately, you're going to answer a whole heap of questions on the integration and control side of things, and spit out something which looks ultimately on a spectrum. Are we closer to employment or closer to independent contracting? But that is now very clearly the test that needs to be applied. With those changes to the law, there's also an opt-out regime. So we can basically say it's okay to continue someone on as an independent contractor, even if in substance they're more like an employee, if they're earning over the high income threshold. That says 175,000 there. It should be 183,000 because it's just been indexed and increased. And that will go up every year. Basically, what needs to happen there is that the contractor at the point of engagement signs an opt-out notice saying, yes, I acknowledge I'm going to earn over that amount during this engagement. And then that means that test won't apply. And that's where you can move forward with, comfortable that there's not much risk. In terms of why I guess this matters, the things that you're risking by calling someone a contractor when in substance they're an employee, penalties for breaching the Fair Work Act, and they can be significant as well, but also back payment of the employee entitlement. So it's possible that that person can turn around and say, well, look, you called me a contractor for all this period, but in substance, I was an employee, so I missed out on annual leave, I missed out on sick leave, notice of termination, and now that we're at the end of the arrangement, I want a redundancy payment as well. So they're the types of things that you can be up for in terms of having to back pay those entitlements. I guess the next thing is, well, what do you do about it? For a lot of businesses, they don't actually really understand how many contractors they've got versus how many employees they've got. It's all a bit of a blur in terms of looking at those engagements. So step one can be map the engagements. Do we have contractors? Do we have a massive area of the business which only engages contractors? And is that actually a red flag, something to be investigated? You might then look at, okay, well, if we do, why is it in one part of the business an issue, in other parts it's not? Or how is it that we've ended up with all these contractors? And that's where you look at your hiring or procurement process. Commonly we see budget being given to a part of the business, but it's limited. The employment budget is spent, but there's a heap of leftover, standard budget. And so, if you do want to go and hire more people, you can't do it as an employee. You've got to make them a contractor just to get around your own internal processes, even though you would have more appropriately called them an employee. So something like just an internal process can inadvertently, on budgeting, can inadvertently create risk of sham contracting. You can think about whether the opt-out notices can be used. They're not going to be as effective as they were planned to be, because the 183,000 is not just a sort of, you can prorate their annual or their day rate into an annual amount and then say, therefore, you're over the cap. It's 183,000 from the engagement. Whether that seems to be an unintended consequence. No one would have expected it to be that way, but that's how they've drafted the legislation, and that's why we're not really seeing anyone use the opt-out notices. And then, of course, your final option there is you can just employ people, and that limits the risk entirely. So, those are the things to think about when it comes to sham contracting. I guess the final just note on sham contracting for a lot of businesses is you do want to think about what is the actual risk of all of those things occurring. We know there are plenty of contractors who are happy to enter into that arrangement. And so the risk of, those penalties or back payment commonly is actually pretty low. That worker is not going to turn around and sue you at the end, or you can be pretty confident they won't. And whether the Fair Work Ombudsman is going to come and audit your business and take issue with that, they can, and they certainly have the right to, and just turn up and audit you. So it can't be ruled out, but there's always a question of whether that would be likely. And then if they did, if someone's comfortably engaged as a contractor, they're not missing out in terms of wages, there's always a question of whether the Ombudsman would put their resources into it, notwithstanding that, they may identify a breach of the law and you want to fix it for that reason, but there's always a bit of a risk profile to be considered on sham contracting. All right, we'll move on to the right to disconnect. Now, this, at the time it came in, I was pretty sure this would be a flop. And I think as time's gone on, ultimately it feels like that's been the case. The right to disconnect, again, this was August last year, a right on the part of an employee to basically refuse contact from an employer when it was outside the working hours, unless that refusal was unreasonable. And now the things that would get considered, why were they contacted? How was the attempt made? Was this an email that was not expected to be answered, or was this, incessant phone calls? What type of disruption was caused by it? And then looking at the employee's remuneration, and the nature of their role, as well as their personal circumstances. That all kind of gets considered when we're determining whether or not an employee's refusal was unreasonable or not. The reason I think there wasn't very much in this is because in other jurisdictions overseas where, sort of the idea for a right to disconnect came, France and Germany initially, there were actual prohibitions on an employer in relation to contacting employees outside of work hours. And that was a much more significant change, where what we have here is absolutely not a prohibition on contacting an employee outside of hours. So in a sense, do businesses need to do very much about this? And the answer is quite possibly no, because you can deal with everything on a case-by-case basis. It's only an issue if an employee refuses your request for contact, and then you take issue with that refusal. And then you can have an argument about whether they've unreasonably refused. So if we move on to, well, what do you do about the right to disconnect? And for a lot of you joining, you will have probably already, got the house in order as we prepared for this almost a year ago now. Yeah, my view was always, well, potentially nothing. I don't think this is a big issue that really changes anything for businesses. And that's largely because, as I said, if an employee does refuse the contact, well, now you've got a dispute. But even if that dispute's going to make its way to the Fair Work Commission, which is where it's going to start to give your business some headaches, a precursor to or a jurisdictional aspect for the employee to be able to make that complaint is they have to have already attempted to resolve it at a workplace level. So yes, the right to disconnect might embolden some employees to say, hey, I'd like to not be contacted after hours. But all it's really going to do is prompt a conversation. And then something where you can resolve it. We have lots of clients who are international businesses with employees who are constantly required to, join a call early or late with the US or the UK or wherever it may be. And those things are still reasonable. And there's always a sort of a global consideration of all those factors. So we haven't seen huge refusals and employees just saying, hey, it's 9 to 5 and 9 to 5 only. The things you can do is certainly train managers so they're aware of, of the right to disconnect, what to do if they actually do have an instance of an employee refusing contact. And you might want to think about policies. Now, policies, in a sense, can be a double-edged sword here. You can implement a policy and suddenly every employee feels really emboldened to exercise the right to disconnect that they may not have been so aware or engaged with. The flip side of it, where it can be helpful, is, if you do have parameters that you would say, look, we will actually expect some reasonable level of contact, so don't get too excited about saying no to it, then a policy can be really helpful and, in a sense, I guess, ward off a complaint or a refusal before it occurs by actually explaining what the right to disconnect is. But as I said, we've had this for almost a year now, and there have been very few applications to the Fair Work Commission on the right to disconnect. And while it got a lot of media attention leading up to it, which probably reported it as far more of a European-style employers can't contact you, I think it has fizzled to a large degree. So hopefully not something that's causing too many headaches for all of you joining today. The next one to move on to is casuals. Now, basically, this is was relatively recent. It's different in terms of the transitional provisions here on whether you're a small business or not. But we've got some simplicity with casual employment now, and basically a definition of casual employment. So you'll now have a casual where there's no firm advance commitment to ongoing work, and they get paid the loading. That basically means that when someone starts as a casual employee, they're going to remain a casual employee until certain triggers occur. So we're always still going to basically consider what was the relationship like at the point of engagement. And we look at those things there, the real substance, practical reality. We look at the contract and what the parties actually understand. But basically what it means is if when you go out to engage someone, you say, hey, I'm giving you casual employment here, and here is a casual contract. I'm not offering you certainty on work. I'm not offering you a fixed roster, and I am going to pay you a 25% loading. Well, now you will have a casual on your hands, and they'll stay a casual until a trigger event. And if we move on to the next slide, we can have a look at what those trigger events are. You will probably know that what we've had up until the beginning of this year was a casual conversion regime, which basically, was ultimately very, very complicated and meant that employers were constantly reaching out to employees at certain intervals, making assessment as to whether or not they were still actually casual and would be able to continue as casual, or whether there could be an offer of permanent employment. So it put a lot of admin on employers. to be basically continually following up with employees to say, hey, would you like to convert? And that's gone as of 26 February this year. It will soon be gone if you're a small business. So from 26 August, that'll be the end of casual conversion. And what we're going to get, or we have for a non-small business, and we will soon have for a small business, is the employee choice pathway. Now, this is really sensible. This is one of the most sensible changes to the law we've had recently. And so basically, the employee, if they've then worked for 6 or 12 months and they don't think they meet that definition of casual employee anymore, they're going to be able to basically say, yes, look, I'd like to convert. What this means is that we know there are many, many, many casual employees out there who are very happy to be a casual employee because they prefer to receive the 25% loading. So if they're happy staying as a casual, they can stay as a casual and doesn't create any liability for the employee, for the employer. It's only when the employee then says, actually, now I'd like to convert, that then we've got to go and consider, whether or not we're going to convert them. Now, the conversion request, you've got 21 days to respond, and you can refuse it on basically business grounds. You can argue with whether or not they are actually, or they no longer meet the definition of casual employment, or you can say things like, well, even if we converted you, we don't have any ongoing employment for you. So we can look at what you were doing and were you actually casual, but we can also look at, well, if we converted you, can we accommodate you moving forward? But we're not seeing very many of these requests because most casuals who actually get to a point where they're getting regular work are happy to have the regular work and the loading. So look, it's a watch this space, but I think this is very much resolved a lot of casual headaches for employers. We click through to what to do. The things you want to be certain about here is your casual employment agreements. So again, we know we have to get things right at the outset of the engagement. And so number one, casual contracts must, and it's helpful at the start to say, by the way, we're not making a firm advance commitment to ongoing work. So let's put that in our letter of offer. But let's also make sure that it's got a casual loading clearly expressed in the contract. So when we set out their pay in the contract, you're getting a base rate of X, you're getting a 25% casual loading of Y, and we want words in there that say that casual loading is compensating you for all of your permanent entitlements. And then we set them out: annual leave, sick leave, notice of termination, redundancy, etc. That way we can be really clear that a casual contract actually looks like a casual contract. And if we just go back a slide there, when the final thing there is just make sure we review the recruitment practices. So again, make sure that we're not accidentally hiring people as casuals when we really mean to hire them as permanent employees. And that if we are hiring casuals, we're sending out the right contracts and all those types of things. All right, wrapping it up now, the final one. I know we've been really rolling through a lot here, but just to touch on, I guess, what's an ever important issue for businesses and regulators and society in general. These changes are actually December 2022, but in relation to sexual harassment, we have a positive duty, which is the change, a positive duty to take all reasonable steps to eliminate workplace sexual harassment, sex discrimination, and sex-based harassment. The key takeaway that I think, for anyone who gets advice on their obligations in relation to sexual harassment, comes to a webinar like this, is to understand. If you take one thing away from it, is to understand what the definition of sexual harassment is and to understand what a low bar it is. And there's the definition there. It's unwelcome conduct of a sexual nature in circumstances where a reasonable person, having regard to all the circumstances, and here's the kicker, would have anticipated the possibility that the person harassed would be offended, humiliated, or intimidated. So we don't really consider there, okay, well, should the person have been upset by this or offended or humiliated by it? Could we have anticipated the possibility that they would have been? And that, as I said, it's a very low bar. In terms of what you do about it, look, there's workplace training is critical, workplace policies, and then making sure you're reviewing whether or not those things are working. And so you might do things like impulse surveys and culture surveys as well. There is a Human Rights Commission guide which gives you 7 key principles in terms of how to actually comply with your positive duty. And I'd really encourage you to go and read that. All right, just the key takeaways here. So wage theft, basically be proactive, do some audits, review your contracts, get on the front foot. Sham contracting, think about what level of risk you're dealing with there, but you can't just rely on having good contracts anymore. So go and assess the relationships. The right to disconnect, as I said, probably a bit of a fizzle. Maybe don't do anything there, just be aware of it. And then moving on to the last one, as we just said with casuals, it's simple now, and that's great. And the critical thing for you to do, get that first engagement right, and then it's over to the employee. So really helpful from a business compliance perspective. And as we've just touched on, sexual harassment, it's a positive duty. You must be doing something, and you must have a framework in place. So basically ensure there is at a minimum something there. All right, well, yes, that's a lot we've been through, so thanks for sticking with me on that. You might find we've got a publication there that you can download. It's Key Employment Law Differences between the UK, New Zealand and Australia. So if you're thinking of expanding or you are across those jurisdictions, that's a really helpful way to get the key differences there, sort of summarised in table format as well. It's really easy to read. We've got some events coming up as well. So the next one, cost-effective dispute management for legal counsel. So that's at the end of August. And you can register there with that link, or any of the materials we'll send you afterwards. You'll be able to do it as well. All right, so we'll get to the Q&A. Just while you're submitting any further questions there, I'll just take a minute to talk to you about LegalVision's desk extension. We have spoken to a lot of C-suite in-house counsel. We know that your in-house lawyers are pulled in so many directions and have to basically put input on internally your business critical stuff, as well as strategic matters, executive level issues. But you've also then got to get through a high volume of BAU matters, or your normal stuff. You've got to do that with a tight budget, and also what we've seen is an even tighter labour market. So with the LegalVision desk extension, we can basically help you with all the BAU legal needs. It means you can cost effectively increase your capability within your team, and it leads you to prioritise working on basically those business critical internal matters. We've got a team of desk extension lawyers. They'll invest up front, basically understand what's important in the business. And then we like to think of it as, operating as an extension of your in-house legal function. So if you do want to know any more about that, just pop your details in when the survey appears at the end. All right, this gives us, moving on to the Q&A, and we'll also, I've just got the poll results here. So it's actually really split in terms of what updates we want to know more about. So wage theft, about a quarter. Interestingly, the right to disconnect and casual is about 40%, which is good, because I really said the right to disconnect was not an issue there. So sorry if that was something everyone really wanted to get into. Work health safety, a lot of the things we've touched on there are relevant to work health safety, particularly the sexual harassment side of things. But of course, absolutely something that LegalVision advises on. And in fact, we set up clients with a work health safety internal process and regime for compliance as well. So something to explore. And we've been through the amendments to the employment law there. So hopefully that has been helpful for everyone. Basically just going to look at some of these questions that have come through. Yeah, okay, so one of them, it is on WHS, and we haven't actually covered much of that today, but I'll I'll still jump into that because it's a good thing to cover. What tips and tricks do you have to manage incoming psychosocial safety requirements coming into effect later in the year? So the psychosocial hazards are significant, I guess, development to the law in relation to safety management, and every business is needing to do something here. Your obligations under safety law is basically to ensure, so far as is reasonably practicable, health and safety of all of your workers. And so there's always a question of how far do you need to go when it comes to compliance here. For psychosocial hazards, they can be far more complicated because I'm moving away from obvious things like, if someone tells you that there's water on the floor, well, we go and check if there's water on the floor and we mop it up, and, physical safety can be a little less complicated, at least from the process perspective. The psychosocial hazards, you're going to need policies in place just to manage everyone's conduct within the business. So some of your psychosocial hazards will be things like discrimination, harassment, bullying. So setting out standards of conduct at work, really critical. But the other aspects of psychosocial hazards move into things like poor change management is a psychosocial hazard, poor reward and recognition, unreasonable job demands. Those things are all expressly considered as psychosocial hazards now. And so in terms of how you manage those things, and policies don't necessarily cover it, the biggest thing there is making sure that managers are aware that those things are risks and that managers need to go and have a look at them. So with anything safety based, you want to basically go and carry out risk assessments. And you can do that in a number of ways with psychosocial hazards. So even just one-on-one meetings with employees is a form of risk assessment. The check-ins, are you okay? Anything that you're dealing with, etc. Just a general forum for people to raise issues is a risk assessment process. And then going into the more sort of broader organizational review, so culture surveys and things like that, where people can actually raise issues, as well as your own internal operational HR teams figuring out structural issues. So, at the moment, there's a very large university being investigated by Safe Work for how it has managed a redundancy process. And so suddenly we've got safety issues in terms of employment matters. So that's where, at that point, ensuring anytime you're doing any sweeping changes or things like that, we've got safety in mind. So yes, there's a lot to be considered with psychosocial hazards, but I think the first part is going and actually considering whether or not, or doing a risk assessment, what are the issues within our business, and also having a look at those issues yourself. There's another question here, any changes in employing someone from another country and changes with amendments, wages. So not a legislative development here, but yes, some very important decisions from the Fair Work Commission you may have seen in relation to overseas workers, particularly those in the Philippines, have been the ones that have made the news recently. Now, historically, when we look at the application of the Fair Work Act, it would say that it applies to an Australian employer and its employees, but there's a carve-out which says if you are engaged outside of Australia to perform work outside of Australia, the Fair Work Act doesn't apply. And for that reason, most businesses said, great, well, if we engage someone in the Philippines and they live and work in the Philippines, we will have engaged them outside Australia and they'll perform work outside Australia, therefore Fair Work Act won't apply. And that all seemed rather uncontroversial, and in my view still seems rather uncontroversial. But we got some decisions from the Fair Work Commission which basically said, well, it's that question of what does it mean to be engaged in? And that's where they flipped the law on its head to a degree and basically said, well, you'll be engaged in Australia by reference to the place where the contract was formed. And then if we look at the local laws which deal with where is a contract formed, they basically say it's the place where the person who's made the offer receives the signed contract. And so that means if you're an Australian business and you send a contract over to someone in the Philippines, they sign it, send it back to you. If your head office is in Australia and you receive that signed agreement, you've just made an agreement in Australia, and therefore that person is engaged in Australia. It's not a particularly, I think it's counterintuitive. And the important thing to remember is it's a decision of a single member of the Fair Work Commission. So it's not sort of, call it, locked in as far as the law is concerned. But you could certainly expect employees, working overseas to now sort of expect, well, hang on, the Fair Work Act might apply. The things a lot of businesses are doing, I mean, some would say, well, this is, it's a limited issue. And most of our, say, Philippine workers they're happy, they're being paid much more than they are in the Philippines, even if they're being paid less than what they would in Australia. And we're not expecting claims. And if the law's not totally clarified or locked in here, let's not do anything. But the businesses who do have a concern about then a flood of, those overseas workers claiming minimum Australian entitlements or bringing unfair dismissal claims or general protections claims, then one of the things that they can do is engage an employer of record locally. So you'd actually just have another entity in that overseas country to employ them directly. It'll cost you more. You'll pay the on cost, basically a labour hire arrangement. You can consider creating your own entity over there that then employs them, but you may run into permanent establishment issues from a tax perspective if you do that. So certainly something to work through and potentially take some advice on if that's, if you want to, if you want to basically limit any kind of liability there. All right, just have a look at some of the other questions that we've got here. So on the new opt-out regime for contractors, is it necessary when contracting through a company or incorporated entity? The answer there is yes. There's always been a consideration that if you've engaged a contractor and they have their own, say, proprietary limited entity that they're engaging with, that you would say, well, we're not sham contracting with an individual here. I've engaged a company to provide services. Now, if you've engaged a company and then they have multiple employees, that company you've engaged has multiple employees who are going to perform all the services for you, then your sham contracting risk really drops down to a significant degree. But if you've got a situation where it's a kind of one-person company, then all those sham contracting risks still exist because the argument would be there that in substance, that individual is an employee and the fact that there's a company in between is not going to get you off the hook. It might be helpful for you in the context of superannuation. Having a company in between can limit the liability or your obligation to pay super to that individual. It's not guaranteed, but it helps. But yeah, less so. It's certainly not a get out of jail free card from an employment perspective. Okay, another one here is, we'll just probably wrap up with this because I know we're getting to the end of time here. Let's talk about wage theft. Wage theft is one thing, but about wage theft by the employee. So if they've overstated their hours or they've claimed that they're a level 3 when they're really only a level 1, does it work? Does it not work both ways? That's a fair question. Basically, no, there's not a criminal offence or a penalty for an employee for, in a sense, misleading the employer in that way. But absolutely, if an employee was overstating their hours, if they were, timesheet fraud, that type of thing, there's certainly things that employers can recover from employees. So certainly you can go back and say, well, we have overpaid you. And there would most likely, if there was going to be any kind of, in that sense, fraud, one of your immediate outcomes there is going to be actually to terminate the employment. So employers absolutely can take action against an employee who's got themselves paid more than they're entitled to. But does the law mean there are penalties in those circumstances? No, the Act doesn't deal with that. It's only there to regulate the employers. All right, so thank you. I know there are plenty that I didn't get to there, and thanks for sending them in. If we haven't got to you there, pop your details in the survey at the end. We can still help out with some of those questions that we didn't answer if you want us to speak to you about those. And you can also talk to us about our membership and how we can help you. So again, we really value the feedback. Please fill out the survey at the end. And once again, thank you, everyone. Thanks so much for joining us today.